Let's get started with a review of New York real estate law and regulation. Which government agency is primarily responsible for enforcing real estate licensing laws in New York State? Is it A, New York Department of State, B, New York State Attorney General's Office, C, New York Real Estate Board, or D, New York Department of Financial Services? The correct answer is A, New York Department of State. The New York Department of State, Division of Licensing Services, is the main authority responsible for enforcing real estate licensing laws and regulations in New York. Which of the following actions is always outside the enforcement authority of the New York Department of State regarding real estate licensees? Is it A, revoking a real estate broker's license, B, investigating complaints against a salesperson, C, sentencing a licensee to jail time, or D, imposing fines for certain violations? The correct answer is C, sentencing a licensee to jail time. Why this is tricky. The Department of State can investigate, discipline, and revoke licenses, but it cannot impose criminal penalties, which are handled by courts, not administrative agencies. A licensed broker in New York is accused of commingling client funds, and the Department of State receives a formal complaint. What is the Department of State authorized to do in response to this complaint? Is it A, refer the complaint directly to a federal agency, B, initiate an investigation and potentially hold a hearing, C, automatically terminate the broker's license without due process, or D, only issue a warning letter with no further action? The correct answer is B, initiate an investigation and potentially hold a hearing. The Department of State can investigate complaints, hold hearings, and impose disciplinary actions such as suspension or revocation of licenses if violations are found. If a New York real estate salesperson is found guilty of a violation, which statement about the Department of State's enforcement options is least accurate? Is it A, the Department of State may suspend the salesperson's license, B, the Department of State may impose a fine on the salesperson, C, the Department of State may revoke the salesperson's license, or D, the Department of State may require the salesperson to pay restitution to the client? The correct answer is D. The Department of State may require the salesperson to pay restitution to the client. Why? This may be tricky. The Department of State can suspend, revoke, or fine, but it cannot require a licensee to pay restitution directly to a client as part of its administrative penalties. After a public hearing, the New York Department of State determines that a broker engaged in fraudulent advertising. What enforcement action can the department legally take against the broker? Is it A, impose criminal charges for fraud, B, refer the case to the local board of realtors for discipline, C, suspend or revoke the broker's license, or D, order the broker to pay punitive damages to consumers? The correct answer is C, suspend or revoke the broker's license. The Department of State can suspend or revoke a broker's license after a hearing if fraud is proven, as part of its enforcement authority under New York law.
How'd you do on the first 5 questions? Go ahead and subscribe to Birdsey now and turn your progress into exam day confidence. Ready to jump back in? Let's go.
Licensing requirements and continuing education. Which New York agency is responsible for issuing real estate licenses? Is it A, New York State Board of Realtors, B, New York Real Estate Commission, C, New York Department of State, Division of Licensing Services, or D, New York Attorney General's Office? The correct answer is C, New York Department of State, Division of Licensing Services. The New York Department of State, Division of Licensing Services, is the official authority responsible for issuing and regulating real estate licenses in New York State? Which of the following is not required to renew a New York real estate salesperson license? Is it A, completion of continuing education courses, B, completion of a new background check, C, payment of the renewal fee, or D, submission of the renewal application before expiration? The correct answer is B, completion of a new background check. Why this can be tricky. All options seem plausible, but only completion of a background check is not required for renewal. It is required for initial licensure, not for renewal. Maria, a licensed New York real estate broker, forgot to complete her continuing education before her license renewal date. What must she do to reactivate her license? Is it A, complete the required continuing education and submit a renewal application with the fee? B, retake the original licensing exam only? C, apply for a new license as a new applicant? Or D, wait 1 year before reapplying for her license? The correct answer is A, complete the required continuing education and submit a renewal application with the fee. Maria must complete the required continuing education and submit a renewal application with the appropriate fee to reactivate her license, as New York requires all continuing education to be current before reactivation. A New York real estate salesperson completed 18 hours of continuing education, including 3 hours of fair housing, before renewal. What is the status of their license renewal application? Is it A, it will be approved because the fair housing requirement is met? B, it will be approved if the applicant submits a written explanation? C, it will be approved with a warning to complete the remaining hours later? Or D, it will be denied until all required hours are completed? The correct answer is D, it will be denied until all required hours are completed. Why this is tricky. The applicant is short of the required 22.5 hours, so the renewal will be denied until all hours are completed, even though the fair housing requirement is met. After moving to New York, Sam wants to become a real estate salesperson and already holds a license in another state. What must he do to obtain a New York license? Is it A, automatically receive a New York license based on his out-of-state license? B, apply for reciprocity if his state has an agreement with New York, or complete New York's requirements if not? C, only submit proof of his out-of-state license with no further requirements? Or D, take only the New York State exam without any other requirements? The correct answer is B, apply for reciprocity if his state has an agreement with New York, or complete New York's requirements if not. Sam must meet New York's requirements, which may include submitting a reciprocity application if his state has an agreement, or otherwise completing New York's education and exam requirements.
If you want more than just rapid-fire questions, head over to birdsey.ai. You can take unlimited practice exams and get instant help from your personal AI study partner. It's like having a tutor 24/7. Try it free. You'll find a link in the description.
Disciplinary actions, penalties, and license violations. Which New York State agency is primarily responsible for investigating complaints and enforcing disciplinary actions against real estate licensees? Is it A, New York State Board of Realtors, B, New York Department of State, Division of Licensing Services, C, New York State Attorney General's Office, or D, New York City Housing Authority? The correct answer is B, New York Department of State, Division of Licensing Services. The New York Department of State, Division of Licensing Services is the main authority for investigating complaints and enforcing disciplinary actions against real estate licensees in New York. Which of the following actions would not typically result in disciplinary action against a New York real estate licensee? Is it A, commingling client funds with personal funds, B, misrepresenting property details to a buyer, C, failing to renew a personal automobile registration. Or D, operating with an expired real estate license. The correct answer is C, failing to renew a personal automobile registration. Why this can be tricky. All options may seem problematic, but only failing to renew a personal automobile registration is unrelated to real estate license law and would not trigger disciplinary action by the Department of State. A broker in Albany is found to have paid an unlicensed person for bringing in a buyer. What penalty can the Department of State impose in this situation? Is it A, suspension or revocation of the broker's license? B, a warning letter only? C, no penalty, as long as the sale closed? Or D, referral to the local police department only? The correct answer is A, suspension or revocation of the broker's license. Paying commissions to unlicensed individuals is a violation, and the Department of State can suspend or revoke the broker's license as a penalty for this action. If a salesperson is found guilty of a license law violation, which statement about the broker's liability is most accurate? Is it A, the broker is always automatically liable? B, the broker is never liable for the salesperson's actions? C, the broker is only liable if the salesperson is a relative? Or D, the broker is liable if they knew or should have known about the violation? The correct answer is D. The broker is liable if they knew or should have known about the violation. Why this is tricky. It may seem the broker is always liable, but the broker is only responsible if they knew or should have known about the violation and failed to take action. During a routine audit, the Department of State discovers that a real estate office has failed to maintain transaction records for the required period. What is the likely consequence for the broker? Is it A, no consequence if no complaints have been filed? B, a verbal warning from the auditor only? C, disciplinary action such as fines or suspension? Or D, immediate criminal prosecution? The correct answer is C, disciplinary action such as fines or suspension. Failure to maintain required records is a violation of New York real estate law and can result in disciplinary action, including fines or suspension of the broker's license. Federal Real Estate Law. Fair Housing Act, Protected Classes, and Prohibited Practices. Which of the following is a protected class under the Federal Fair Housing Act? Is it A, race, B, employment status, C, credit score, or D, pet ownership? The correct answer is A, race. Race is one of the original protected classes under the Federal Fair Housing Act, along with color, religion, and national origin. Later amendments added sex, disability, and familial status as protected classes. Which of the following is not prohibited by the Fair Housing Act when renting a dwelling? Is it A, refusing to rent to a family with children? B, refusing to rent based on religion? C, refusing to rent to someone who cannot afford the rent? Or D, refusing to rent based on national origin? The correct answer is C, refusing to rent to someone who cannot afford the rent. Why this can be tricky. The Fair Housing Act does not prohibit refusing to rent to someone who cannot afford the rent. It does prohibit discrimination based on protected classes such as race, religion, or familial status. A landlord tells a prospective tenant that only adults without children may apply for an apartment in a building, which is not a designated senior housing community. Does this violate the Fair Housing Act? Is it A, yes, this is illegal discrimination based on familial status? B, no, landlords can set any occupancy rules they want? C, no, unless the building is government subsidized? Or D, yes, but only if the tenant is also disabled? The correct answer is A. Yes, this is illegal discrimination based on familial status. Familial status, which includes families with children under 18, is a protected class. Unless the building qualifies as senior housing, excluding families with children is prohibited under the Fair Housing Act. Which of the following statements about the Fair Housing Act is accurate? Is it A, the Act applies to all housing with no exceptions? B, the Act prohibits discrimination based on national origin? The Act only applies to government-owned housing? Or D, the Act allows discrimination based on disability if the building is not accessible? The correct answer is B. The Act prohibits discrimination based on national origin. Why this is tricky? The Fair Housing Act covers most residential housing, but there are limited exemptions, such as owner-occupied buildings with 4 or fewer units. It does not cover all housing without exception. A real estate agent refuses to show homes in a certain neighborhood to buyers of a specific national origin, claiming it is for their safety. Does this action violate the Fair Housing Act? Is it A, no, the agent is acting in the client's best interest? B, no, unless the buyers complain to authorities? C, yes, this is illegal steering based on national origin? Or D, yes, but only if the neighborhood is predominantly one ethnicity? The correct answer is C, yes, this is illegal steering based on national origin. Steering clients away from neighborhoods based on national origin is prohibited under the Fair Housing Act. The agent's stated reason does not justify this discriminatory practice.
Have you noticed the code in the bottom corner? The next time you're stumped, take that code to birdsey.ai. You'll get immediate help, complimentary study sessions, and access to hundreds of additional questions. It's the best tool to help you pass with confidence.
Americans with Disabilities Act requirements. Which of the following is a requirement under the Americans with Disabilities Act for newly constructed commercial properties? Is it A, they must be accessible to individuals with disabilities? B, they must provide free parking for all visitors? C, they must be located near public transportation? Or D, they must have at least 2 elevators? The correct answer is A. They must be accessible to individuals with disabilities. The ADA requires that newly constructed commercial properties be accessible to individuals with disabilities, including features such as accessible entrances, restrooms, and routes within the building. Which statement about the Americans with Disabilities Act and existing buildings is not accurate? Is it A, existing buildings must remove barriers when it is readily achievable? B, alterations to existing buildings must comply with ADA accessibility standards? C, all existing buildings must be fully retrofitted regardless of cost? Or D, barrier removal requirements depend on the nature and cost of the changes? The correct answer is C. All existing buildings must be fully retrofitted regardless of cost. Why this is tricky? The ADA does not require all existing buildings to be fully retrofitted, but it does require removal of barriers when it is readily achievable, which depends on cost and feasibility. Under the ADA, which of the following is least likely to be considered a reasonable modification for a commercial landlord to make? Is it A, installing a ramp at the main entrance? B, completely rebuilding the structure to add an additional floor? C, widening doorways for wheelchair access? Or D, adding accessible signage for restrooms? The correct answer is B, completely rebuilding the structure to add an additional floor. Why this may be tricky? The ADA requires reasonable modifications, but not those that would fundamentally alter the nature of the business or impose undue financial or administrative burdens. A property manager is overseeing renovations at a shopping center built before the ADA was enacted, and is asked whether the new restrooms must be accessible under the law. What is the correct requirement? Is it A, no changes are required because the building is old? B, only entrances must be updated, not restrooms. Altered restrooms must be made accessible to individuals with disabilities. Or D, accessibility is optional if the cost is too high. The correct answer is C. Altered restrooms must be made accessible to individuals with disabilities. When alterations are made to areas like restrooms in existing facilities, the ADA requires that those altered areas be made accessible to individuals with disabilities, even if the building itself predates the ADA. A tenant with a mobility impairment requests to install a grab bar in the restroom of their leased office space. Who is responsible for the cost under the ADA? Is it A, the landlord must pay for all modifications? B, the tenant is responsible for the cost of modifications within their leased space? C, the government provides funding for all ADA modifications? Or D, no modifications are allowed without landlord approval? The correct answer is B. The tenant is responsible for the cost of modifications within their leased space. Under the ADA, tenants are generally responsible for the cost of modifications in their own leased spaces unless otherwise agreed in the lease, but landlords cannot prohibit reasonable modifications. RESPA and Truth in Lending Act terminology. Which document is required by the Real Estate Settlement Procedures Act to disclose all settlement costs to the borrower before closing? Is it A, closing disclosure, B, deed of trust, C, promissory note, or D, title commitment? The correct answer is A, closing disclosure. A closing disclosure is mandated by RESPA to provide borrowers with a detailed list of all settlement costs prior to closing, ensuring transparency and informed decision-making. Which of the following is not covered by the Truth in Lending Act's disclosure requirements? Is it A, annual percentage rate, B, total finance charge, C, appraised value of the property, or D, payment schedule? The correct answer is C, appraised value of the property. Why this can be tricky? The Truth in Lending Act requires disclosure of loan terms, finance charges, and the annual percentage rate, but it does not require disclosure of the property's appraised value. Maria is purchasing her first home and receives a loan estimate from her lender. What is the main purpose of this document in her transaction? Is it A, to finalize her mortgage interest rate, B, to inform her of estimated loan terms and closing costs, to transfer title to the property, or D, to schedule her closing appointment? The correct answer is B, to inform her of estimated loan terms and closing costs. The loan estimate helps Maria compare loan offers by providing key terms and estimated costs as required by federal law, so she can make an informed decision before proceeding. Under RESPA, which fee may a lender legally receive for referring a borrower to a specific title company? Is it A, a flat referral fee, B, a percentage of the title insurance premium, C, a gift card as a thank you, or D, no fee at all? The correct answer is D, no fee at all. Why this is tricky? RESPA strictly prohibits referral fees or kickbacks for settlement service referrals. Lenders may not receive any fee for referring borrowers to a title company. A lender fails to provide the required truth in lending disclosures to a borrower before closing. What is the likely consequence for the lender? Is it A, the borrower must pay a higher interest rate, B, the property transaction is automatically voided, C, the lender may face regulatory penalties and civil liability, or D, the borrower is required to reapply for the loan? The correct answer is C, The lender may face regulatory penalties and civil liability. Failure to provide required truth in lending disclosures can result in regulatory penalties and potential civil liability for the lender, as these disclosures are mandated by federal law. Property ownership and land use. Forms of real property ownership. Which form of real property ownership allows two or more people to own property with equal rights of possession and the right of survivorship? Is it A, joint tenancy, B, tenancy in common, C, community property, or D, sole ownership? The correct answer is A, joint tenancy. Joint tenancy allows two or more people to own property together with equal rights and includes the right of survivorship, meaning the surviving owners automatically receive the deceased owner's share. Which of the following is not a characteristic of tenancy in common? Is it A, owners may have unequal shares, B, each owner can sell their interest without others' consent, C, there is a right of survivorship among owners, or D, each owner has an undivided interest in the property? The correct answer is C. There is a right of survivorship among owners. Why this can be tricky? Tenancy in common allows unequal interests and no right of survivorship, but owners can sell or transfer their shares freely. Survivorship is not a feature of tenancy in common. All of the following statements about community property are true, except which one? Is it A, property acquired during marriage is generally community property, B, property acquired before marriage is always community property, C, both spouses have equal ownership of community property, or D, community property laws apply only to certain states? The correct answer is B, property acquired before marriage is always community property. Why this is tricky? Community property is generally acquired during marriage and owned equally, but property acquired before marriage is usually considered separate, not community property. Maria and Lee, who are not married, purchase a home together and want to ensure that if one dies, the other automatically becomes the sole owner. Which form of ownership should they choose? Is it A, tenancy in common, B, joint tenancy, or D, tenancy by the entirety? The correct answer is B, joint tenancy. Joint tenancy is the form of ownership that provides the right of survivorship, ensuring that if one owner dies, the other automatically becomes the sole owner. Sam owns a condominium unit and has exclusive ownership of his unit, but shares ownership of the common areas with other unit owners. What type of ownership does Sam have? Is it A, cooperative ownership, B, fee simple absolute ownership, C, leasehold ownership, or D, condominium ownership? The correct answer is D, condominium ownership. Sam has condominium ownership, which gives him exclusive rights to his unit, and shared ownership of common areas with other unit owners.
Did you get a different answer? Or maybe you have a question about the exam in general? Drop it in the comments below. We read and answer them personally.
Land descriptions and property boundaries. Which method of legal land description uses a starting point, compass directions, and distances to define property boundaries? Is it A, meets and bounds, B, lot and block, C, rectangular survey, or D, government lot? The correct answer is A, meets and bounds. The meets and bounds system describes land by referencing a starting point and then using compass directions and distances to outline the property boundaries. This method is commonly used for irregularly shaped parcels. Which of the following is not a component of the rectangular survey system? Is it A, township lines, B, range lines, C. Benchmarks, or D. Principal meridians? The correct answer is C. Benchmarks. Why this can be tricky. All options sound related to land descriptions, but only township lines, range lines, and principal meridians are part of the rectangular survey system. Benchmarks are reference points for elevation, not boundary descriptions in this system. A property described as the northwest quarter of the southeast quarter of Section 10 contains how many acres? Is it A, 160 acres, B, 40 acres, C, 80 acres, or D, 10 acres? The correct answer is B, 40 acres. Why this is tricky? The description involves fractions of a section. One section is 640 acres. A quarter of a quarter is 1/16, so the property is 40 acres, not 160 or 80, as might be mistakenly calculated. Maria buys a home and discovers the neighbor's fence is 2 feet inside her property line, according to the survey. What is this situation called? Is it A, easement, B, license, C, encroachment, or D, lien? The correct answer is C, encroachment. This is an encroachment, which occurs when a structure extends onto another person's property without permission. Encroachments can lead to disputes and may require legal resolution or removal of the structure. A developer records a subdivision plat that divides land into numbered lots with streets. What method of land description is being used? Is it A, meets and bounds, B, lot and block, C, rectangular survey, or D, monument system? The correct answer is B, lot and block. The lot and block system is used when land is divided into lots and blocks on a recorded plat map. This method is common in urban and suburban developments for clear identification of parcels. Easements, liens, and encumbrances. What is the primary purpose of an easement appurtenant? Is it A, to benefit a neighboring property owner, B, to secure a loan against the property, C, to restrict the use of the property for environmental reasons, or D, to allow temporary use for construction purposes only? The correct answer is A, to benefit a neighboring property owner. An easement appurtenant allows the owner of one parcel to use a portion of a neighboring parcel for a specific purpose, such as access. It benefits the dominant tenement and runs with the land, transferring with ownership. Which of the following is not considered an encumbrance on real property? Is it a recorded easement, B, a mechanic's lien, C, a building permit, or D, a deed restriction? The correct answer is C, a building permit. Why this is tricky? All options except for a building permit are forms of encumbrances. A building permit is a government authorization, not a claim, lien, or restriction on title. If a property has a recorded easement by necessity, which statement is least accurate? Is it A, it allows access to otherwise landlocked property, B, it is automatically terminated if the dominant and servient tenements are sold to different owners, C, it is created by law when necessary for reasonable use, or D, it benefits the dominant tenement? The correct answer is B, it is automatically terminated if the dominant and servient tenements are sold to different owners. Why this can be tricky? Easements by necessity are created when landlocked parcels need access. They are not automatically terminated if the dominant and servient tenements are sold to different owners. Maria owns a property that is subject to a utility easement, and the utility company needs to dig a trench across her yard to repair underground cables. What right does the utility company have in this situation? Is it A, they can use the entire property for any purpose, B. They must obtain Maria's written permission each time. C. They may access the easement area for repairs as needed. Or D. They must compensate Maria for any inconvenience regardless of damage. The correct answer is C. They may access the easement area for repairs as needed. The utility company has the right to reasonably access and use the easement area for maintenance or repairs, as specified in the easement agreement, but must avoid unnecessary damage. A lender records a lien against Tom's property after he defaults on his mortgage, and Tom later sells the property to Lisa. Is it A. The lien is automatically removed upon sale? B. The lien remains attached to the property? C. The lien transfers to Tom's new property? Or D. The lien is converted into an easement for Lisa? The correct answer is B. The lien remains attached to the property. The lien remains attached to the property after the sale, so Lisa takes title subject to the existing lien unless it is satisfied before transfer. Government powers and land use controls. Which government power allows the state to take private property for public use with compensation to the owner? Is it A. Eminent domain? B. Police power? C. Escheat? Or D. Taxation? The correct answer is A. Eminent domain. Eminent domain is the government's power to take private property for public use, provided the owner receives just compensation. This is a fundamental concept in property law and is protected by the Constitution. Which of the following is not an example of the government's police power over land use? Is it A. Zoning ordinances? B. Building codes? C. Condemnation? Or D. Environmental regulations? The correct answer is C. Condemnation. Why this can be tricky. All options except condemnation involve regulation of land use. Condemnation is the process of taking property under eminent domain, not a regulatory action under police power. A city council passes a new law requiring all homes in a neighborhood to have fire-resistant roofing. What government power is being exercised in this situation? Is it A. Eminent domain? B. Police power? C. Escheat? Or D. Taxation? The correct answer is B. Police power. This is an example of police power, which allows the government to regulate property for the health, safety, and welfare of the public, such as through building codes and safety requirements. If a property owner dies intestate and with no heirs, which government power allows the state to claim ownership of the property? Is it A. Taxation? B. Eminent domain? Or D. The correct answer is D. Escheat. Why this is tricky. The question may mislead some to think of eminent domain or police power, but escheat is the correct government power when there are no heirs or will. A developer wants to build a shopping center, but the city denies the permit because the land is zoned for residential use only. Which government power is the city using in this decision? Is it A. Eminent domain? B. Taxation? C. Police power? Or D. The correct answer is C. Police power. The city is exercising its police power, which includes zoning authority to regulate land use for the community's welfare, such as restricting commercial development in residential zones. Contracts. Elements of a valid contract. Which of the following is always required for a contract to be legally valid? Is it A. Mutual agreement? B. A written document? C. A witness signature? Or D. A notary seal? The correct answer is A. Mutual agreement. A valid contract must have mutual agreement, consideration, competent parties, and a lawful object. These elements are required by contract law to ensure enforceability. Which element is not necessary for a contract to be valid under general contract law? Is it A, lawful object, B, consideration, C, specific closing date, or D, mutual consent? The correct answer is C, specific closing date. Why this is tricky: all options seem important, but only a lawful object, mutual consent, and consideration are always required. A specific closing date is not a universal requirement for contract validity. Maria, age 16, signs a contract to buy a car from a dealership. Can this contract be enforced against Maria? Is it A, because she signed voluntarily, B, no, because she is a minor, C, yes, if the contract is for a luxury item, or D, no, unless the contract is notarized? The correct answer is B, no, because she is a minor. Because Maria is a minor, she generally lacks legal capacity to contract. Contracts with minors are usually voidable at the minor's option, so the contract cannot be enforced against her unless an exception applies. Which statement about consideration in a contract is most accurate? Is it A, it must always be money, B, it must be of equal value to both parties, or D, it can be a promise to do or not do something? The correct answer is D, it can be a promise to do or not do something. Why this can be tricky: consideration does not have to be money or equal in value. It can be anything of legal value exchanged between parties, including promises or services. If a contract requires an illegal act, such as selling prohibited substances, is this contract enforceable in court? Is it A, yes, if both parties agree, B, yes, if the contract is in writing, C, no, because the object is illegal, or D, no, unless the parties are unaware of the law? The correct answer is C, no, because the object is illegal. A contract with an illegal object is void and unenforceable. Courts will not enforce agreements that require illegal acts. Purchase and listing agreement terminology. Which term in a listing agreement specifies the length of time the broker has to find a buyer for the property? Is it commission clause, B, listing period, C, earnest money deposit, or D, contingency clause? The correct answer is B, listing period. The listing period defines the duration of the broker's authority to market and sell the property. This is a standard element in listing agreements and is essential for both the broker and seller to understand. Which of the following is not typically included as a required element in a valid purchase agreement? Is it A, legal description of the property, B, purchase price, C, buyer's credit score, or D, signatures of the parties? The correct answer is C, buyer's credit score. Why this can be tricky: all options seem important, but only the legal description, purchase price, and signatures are required elements. The buyer's credit score is not a standard requirement for contract validity. Maria signs an exclusive right-to-sell listing with a broker, but later finds a buyer herself. Who is entitled to the commission under this agreement? Is it A, only Maria, since she found the buyer herself, B, no one, because the broker did not find the buyer, C, the buyer as an incentive for direct purchase, or D, the broker, because the agreement guarantees commission if the property sells? The correct answer is D, the broker, because the agreement guarantees commission if the property sells. In an exclusive right-to-sell listing, the broker earns a commission regardless of who finds the buyer. This protects the broker's interests and is a key feature of this agreement type. If a listing agreement is missing the property's legal description but includes the address, is it always considered valid? Is it A, yes, because the address is sufficient for identification? B, no, because a legal description is generally required for validity? C, yes, if both parties agree to the terms. Or D, only if the broker waives the requirement in writing. The correct answer is B, no, because a legal description is generally required for validity. Why this is tricky? Many assume an address is enough, but a legal description is typically required for clarity and enforceability. Without it, the agreement may not be valid in many jurisdictions. A seller accepts an offer, but the buyer's financing falls through before closing. According to most purchase agreements, what happens to the earnest money deposit? Is it A, it is returned to the buyer? B, it is automatically forfeited to the seller? C, it is split equally between buyer and seller? Or D, it is paid to the broker as a fee? The correct answer is A, it is returned to the buyer. Most purchase agreements have a financing contingency, so if the buyer's loan is denied, the earnest money is typically returned to the buyer, provided all deadlines and notice requirements are met. Contract performance, breach, and remedies. What is the primary purpose of awarding compensatory damages in a contract breach? Is it A, to punish the breaching party? B, to compensate the non-breaching party for actual losses? C, to reward the breaching party for partial performance? Or D, to void the contract entirely? The correct answer is B, to compensate the non-breaching party for actual losses. Compensatory damages are intended to put the non-breaching party in the position they would have been in if the contract had been performed as agreed, making up for actual losses suffered. Which of the following is not generally considered a remedy for breach of contract? Is it A, specific performance? B, rescission? C, novation? Or D, damages? The correct answer is C, novation. Why this can be tricky? The list includes both remedies and unrelated concepts. Only specific performance, rescission, and damages are standard remedies. Novation is a contract modification, not a remedy for breach. If a party to a contract substantially performs but does not complete every detail, what is the most likely legal consequence? Is it A, the contract is automatically voided? B, the non-breaching party owes nothing? C, the breaching party is entitled to punitive damages? Or D, the performing party may recover the contract price minus damages for defects? The correct answer is D, the performing party may recover the contract price minus damages for defects. Why this is tricky? Substantial performance usually entitles the performing party to payment minus deductions for defects, rather than a total loss or contract cancellation. Maria hires a contractor to build a deck, but the contractor stops work halfway through without cause. What remedy is Maria most likely entitled to under contract law? Is it A, damages to cover the cost of completion? B, specific performance requiring the contractor to finish the deck? C, punitive damages for the contractor's behavior? Or D, no remedy since the work was started? The correct answer is A, damages to cover the cost of completion. Maria can seek damages to cover the cost of hiring someone else to finish the deck, as this compensates her for the contractor's breach and actual loss. A seller delivers goods to a buyer 2 days late, causing the buyer no financial loss. What is the most likely outcome if the buyer sues for damages? Is it A, the seller must pay substantial compensatory damages? B, the contract is automatically terminated? The buyer may receive nominal damages only? Or D, the seller is required to pay punitive damages? The correct answer is C. The buyer may receive nominal damages only. Because the buyer suffered no actual loss, the court is likely to award only nominal damages, recognizing the breach but not providing substantial compensation. Disclosure and cancellation rights. Which document is typically required to inform a buyer of their right to cancel a residential real estate contract within a specified period? Is it A, listing agreement, B, deed of trust, C, disclosure statement, or D, title insurance policy? The correct answer is C, disclosure statement. A disclosure statement is required to inform buyers of their right to cancel within a certain period. This ensures buyers are aware of their rights and the process for exercising them, as mandated by most real estate authorities. Which of the following is not typically a valid reason for a buyer to cancel a contract under statutory disclosure laws? Is it A, failure to disclose known defects, B, omission of required environmental hazards information, C, non-receipt of the mandated disclosure form, or D, change of mind about the neighborhood? The correct answer is D, change of mind about the neighborhood. Why this can be tricky. Statutory disclosure laws focus on material facts and required disclosures. Personal preference changes are not protected grounds for cancellation under these laws, even if other options seem plausible. If a seller delivers the required property disclosure form after the buyer has signed the contract, what is the most likely effect on the buyer's cancellation rights? Is it A, the buyer loses the right to cancel, B, the cancellation period begins upon receipt of the disclosure, C, the seller must renegotiate the contract terms, or D, the buyer must accept the property as is? The correct answer is B. The cancellation period begins upon receipt of the disclosure. Why this is tricky. Late delivery of disclosures usually extends or restarts the buyer's cancellation period rather than eliminating it. Many test takers mistakenly believe the right is lost or unchanged. Maria signs a purchase agreement for a home and receives the required disclosure documents 2 days later. How long does Maria have to cancel the contract based on receiving the disclosures? Is it A, a specific number of days from the date she receives the disclosures, B, until the closing date of the transaction, C, from the date she signed the contract, regardless of disclosure delivery, or D, only if the seller agrees in writing? The correct answer is A, a specific number of days from the date she receives the disclosures. Maria's cancellation period starts when she receives the disclosures, not when she signs the contract. The exact number of days depends on local law, but the key is that the clock starts upon receipt. After reviewing the property disclosure, John discovers a material defect that was not previously mentioned. What is John's most likely recourse regarding the contract? Is it A, he must proceed with the purchase as agreed, B, he can demand a lower purchase price but cannot cancel, C, he may cancel the contract within the allowed period, or D, he can only sue for damages after closing? The correct answer is C, he may cancel the contract within the allowed period. If a material defect is discovered that was not disclosed, John may have the right to cancel the contract within the statutory period, protecting buyers from undisclosed issues. Agency relationships. Types of agency and representation. Which type of agency relationship allows a real estate agent to represent both the buyer and the seller in the same transaction, provided both parties give informed consent? Is it A, dual agency, B, single agency, C, designated agency, or D, subagency? The correct answer is A, dual agency. Dual agency occurs when one agent or brokerage represents both the buyer and the seller in a transaction, but only if both parties give their informed consent as required by law. Which of the following is not a type of agency relationship recognized in most real estate transactions? Is it A, single agency, B, dual agency, C, transactional agency, or D, implied agency? The correct answer is C, transactional agency. Why this can be tricky? The term implied agency is recognized, but transactional agency is not a true agency relationship. It refers to a non-agency or facilitator role, which is not an agency relationship. Maria, a broker, assigns one of her agents to represent the seller and another to represent the buyer in the same transaction within her firm. What type of agency relationship does this create? Is it A, dual agency, B, designated agency, C, subagency, or D, single agency? The correct answer is B, designated agency. This situation describes designated agency, where different agents within the same brokerage represent opposing parties in the same transaction, maintaining separate fiduciary duties to each client. If an agent acts on behalf of a client without a written agreement, but with the client's knowledge and acceptance, what type of agency has most likely been created? Is it A, exclusive agency, B, dual agency, C, subagency, or D, implied agency? The correct answer is D, implied agency. Why this is tricky? Many assume agency must be written, but implied agency can arise from the actions and conduct of the parties, even without a formal agreement. A buyer contacts a listing agent directly, and the agent assists the buyer without informing the seller. What type of agency relationship is most likely created between the agent and the buyer? Is it A, single agency, B, dual agency, C, implied agency, or D, no agency? The correct answer is C, implied agency. By assisting the buyer without disclosure or a written agreement, the agent may unintentionally create an implied agency relationship with the buyer based on their actions. Agency duties and fiduciary responsibilities. Which duty requires an agent to act solely in the best interest of the principal at all times? Is it A, loyalty, B, obedience, C, disclosure, or D, reasonable care? The correct answer is A, loyalty. The duty of loyalty obligates an agent to always act in the principal's best interest, avoiding conflicts of interest and prioritizing the principal's needs above all others. Which of the following is not a fiduciary duty owed by an agent to a principal? Is it A, accounting, B, loyalty, C, marketing, or D, disclosure? The correct answer is C, marketing. Why this is tricky? All options sound like duties, but only accounting, loyalty, and disclosure are fiduciary duties. Marketing is a service, not a fiduciary responsibility under agency law. An agent must always disclose every fact they know about a property to all parties, even if it harms their principal's position, correct? Is it A, yes, always? B, no, only material facts must be disclosed to all parties? C, yes, unless the principal objects? Or D. No. Agents never disclose anything without principal approval. The correct answer is B. No. Only material facts must be disclosed to all parties. Why this may be tricky. Agents must disclose material facts to all parties, but they should not reveal confidential information that could harm their principal, unless required by law. Maria, a real estate agent, receives an offer on her client's property, but knows of another buyer who may offer more. What is her fiduciary responsibility in this situation? Is it A. Accept the first offer on behalf of her client? B. Withhold the second buyer's interest to avoid confusing the client? C. Inform her client about both the offer and the other interested buyer? Or D. Advise the second buyer to wait before making an offer? The correct answer is C. Inform her client about both the offer and the other interested buyer. Maria must promptly present all offers to her client and inform them of any potential interest from other buyers, fulfilling her duties of disclosure and loyalty. A seller's agent learns confidential financial information about the seller during a listing appointment. What must the agent do with this information if a potential buyer asks about the seller's finances? Is it A. Refuse to disclose the seller's confidential financial information? B. Share the information if the buyer insists? C. Disclose only part of the information to appear helpful? Or D. Ask the seller for permission, then disclose regardless of their answer? The correct answer is A. Refuse to disclose the seller's confidential financial information. The agent must protect the seller's confidential information and not disclose it to the buyer, unless required by law, to uphold the duty of confidentiality. Agency disclosure requirements in New York. When is a New York real estate agent required to provide an agency disclosure form to a prospective buyer or seller? Is it A. At the first substantive contact with the consumer? B. Only after a purchase offer is submitted? C. At the closing of the transaction? Or D. When the listing agreement is signed by the seller only? The correct answer is A. At the first substantive contact with the consumer. A New York real estate agent must provide the agency disclosure form at the first substantive contact with a prospective buyer or seller, ensuring the consumer understands the agent's role before confidential information is shared. Which of the following is not a situation where the New York agency disclosure form is required? B. A broker leasing commercial office space. C. A broker assisting a seller of a two-family house. Or D. A broker working with a buyer of a condominium unit. The correct answer is B. A broker leasing commercial office space. Why this can be tricky. The disclosure form is not required for commercial transactions, but is required for residential 1 to 4 family homes. So it's easy to overlook the exception for commercial property. Maria, a licensed salesperson, meets with a couple interested in purchasing a co-op apartment in New York and begins discussing their financial qualifications. What must Maria do at this point? Is it A. Wait until the couple makes an offer to provide the disclosure form? B. Provide the disclosure form only if the couple requests it? Present the agency disclosure form before continuing the conversation? Or D. Give the disclosure form at the closing table? The correct answer is C. Present the agency disclosure form before continuing the conversation. Maria must provide the agency disclosure form before discussing confidential information, such as financial qualifications, to comply with New York's agency disclosure requirements. If a New York agent is acting as a dual agent with designated sales agents, which statement about agency disclosure is accurate? Is it A. No disclosure is necessary if both parties are aware of the arrangement? B. Only the buyer must sign the agency disclosure form? C. Oral disclosure is sufficient if both parties agree. Or D. Both parties must give written informed consent to dual agency with designated sales agents. The correct answer is D. Both parties must give written informed consent to dual agency with designated sales agents. Why this is tricky? Dual agency with designated sales agents requires written informed consent from both parties, which is a step beyond standard disclosure and can be easily confused with regular dual agency rules. During an open house for a single-family home in New York, Agent Tom is approached by an unrepresented buyer who asks detailed questions about the property's condition. What is Tom required to do regarding agency disclosure? Is it A. Wait until the buyer submits a written offer to provide the disclosure form? B. Present the agency disclosure form before answering the buyer's questions? C. Only provide the disclosure form if the buyer requests representation? Or D. No disclosure is needed at an open house under any circumstances? The correct answer is B. Present the agency disclosure form before answering the buyer's questions. Tom must provide the agency disclosure form to the unrepresented buyer before discussing confidential or substantive information about the property, as required by New York law. Real estate finance. Loan types and financing terminology. Which type of loan is most commonly used for residential real estate purchases in the United States? Is it A. Conventional loan, B. Bridge loan, C. Reverse mortgage, or D. Construction loan? The correct answer is A. Conventional loan. A conventional loan is the most common type of financing for residential real estate purchases in the United States, typically offered by private lenders and not insured or guaranteed by the government. Which of the following statements about adjustable rate mortgages is not true? Is it A. The interest rate can change over time? B. They often start with a lower initial rate than fixed-rate mortgages? C. The interest rate is fixed for the entire loan term? Or D. Rate adjustments are usually tied to an index such as the LIBOR or Treasury rate? The correct answer is C. The interest rate is fixed for the entire loan term. Why this can be tricky? The distractors are all true statements about adjustable rate mortgages, but the correct answer is the one that incorrectly describes how the interest rate is set. A balloon mortgage requires the borrower to pay which of the following at the end of the loan term? Is it A. No further payments, B. A large lump sum payment, C. Only interest accrued during the loan term, or D. A prepayment penalty? The correct answer is B. A large lump sum payment. Why this is tricky? The term balloon may mislead test takers to think payments are spread evenly, but the key feature is a large final payment due at the end. Maria is purchasing her first home and wants a loan insured by the federal government to allow for a lower down payment. Which type of loan should her lender recommend? Is it A. Conventional loan, B. VA loan, C. Jumbo loan, or D. FHA loan? The correct answer is D. FHA loan. An FHA loan is insured by the federal government and is designed to help buyers with lower down payments and less stringent credit requirements, making it ideal for first-time home buyers like Maria. A real estate investor wants to finance the purchase of multiple rental properties at once. Which loan type is most appropriate for this situation? Is it A. Reverse mortgage, B. Blanket mortgage, C. FHA loan, or D. Fixed rate mortgage? The correct answer is B. Blanket mortgage. A blanket mortgage allows a borrower to finance multiple properties under a single loan, making it suitable for investors purchasing several properties at the same time. Mortgage concepts and lending instruments. Which document typically gives a lender the right to foreclose on a property if the borrower defaults on the loan? Is it A, mortgage or deed of trust? B, promissory note. C, title insurance policy. Or D, purchase agreement. The correct answer is A, mortgage or deed of trust. A mortgage or deed of trust is the document that secures the loan and gives the lender the right to foreclose if the borrower fails to meet the loan obligations. This is a fundamental concept in real estate finance. Which of the following is not typically considered a lending instrument in a real estate transaction? Is it A, mortgage, B, deed of trust, C, purchase agreement, or D, promissory note? The correct answer is C, purchase agreement. Why this is tricky? All the options may appear related to real estate finance, but only one is not a lending instrument. The purchase agreement is a contract for sale, not a tool for securing or evidencing a loan. If a borrower pays off a mortgage early, which clause in the loan agreement could require them to pay an additional fee? Is it A, acceleration clause, B, prepayment penalty clause, C, due on sale clause, or D, defeasance clause? The correct answer is B, prepayment penalty clause. Why this can be tricky? Borrowers may confuse prepayment penalties with other clauses. Only the prepayment penalty clause specifically addresses fees for paying off a loan before its scheduled end date. Maria is buying her first home, and her lender requires her to sign a document that makes her personally responsible for repaying the loan. Which document is this? Is it A, mortgage, B, deed of trust, C, title insurance policy, or D, promissory note? The correct answer is D, promissory note. The promissory note is the document that creates the borrower's personal obligation to repay the loan. It is separate from the mortgage or deed of trust, which secures the loan with the property. A lender agrees to lend money to Tom for a home purchase, but requires that the property itself serve as collateral. What type of security instrument will the lender most likely use? Is it A, promissory note, B, mortgage or deed of trust, purchase agreement, or D, appraisal report? The correct answer is B, mortgage or deed of trust. In most real estate transactions, the lender uses a mortgage or deed of trust to secure the loan with the property as collateral. This allows the lender to foreclose if Tom defaults. Default, foreclosure, and redemption concepts. What is the primary purpose of a redemption period in real estate foreclosure? Is it A, to give the borrower a final chance to pay off the debt and reclaim the property? B, to allow the lender to increase the interest rate on the loan? C, to transfer ownership to a third party immediately after default? Or D, to reduce the outstanding loan balance automatically? The correct answer is A, to give the borrower a final chance to pay off the debt and reclaim the property. A redemption period allows a borrower to reclaim their property after foreclosure by paying the full amount owed, including costs. This period is designed to protect borrowers from losing their property permanently without a final opportunity to pay off the debt. Which of the following statements about deficiency judgments after foreclosure is not accurate? Is it A, a deficiency judgment allows a lender to recover the remaining debt after a foreclosure sale? B, some states prohibit deficiency judgments on certain types of loans? C, a lender can always obtain a deficiency judgment regardless of state law? Or D, deficiency judgments are only possible if the foreclosure sale does not cover the full debt? The correct answer is C, a lender can always obtain a deficiency judgment regardless of state law. Why this can be tricky? The question asks for the statement that is not accurate. and some options may sound plausible. Not all states allow deficiency judgments, and the process depends on local law, not just the lender's wishes. If a borrower defaults on a mortgage, the lender must always foreclose through the court system before selling the property, correct? Is it A, yes, court involvement is always required? B, no, some states allow non-judicial foreclosure without court action. C, only if the borrower requests a hearing. Or D, only for commercial properties, not residential. The correct answer is B, no, some states allow non-judicial foreclosure without court action. Why this is tricky. The word always is misleading. Some states allow non-judicial foreclosure, which does not require court action. The process depends on the type of foreclosure permitted in the jurisdiction. Maria missed several mortgage payments, and her lender began foreclosure proceedings. If Maria pays the full amount owed before the sale date, what is this process called? Is it A, deficiency judgment, B, statutory redemption, C, reinstatement, or D, acceleration? The correct answer is C, reinstatement. This describes the right of reinstatement, which allows a borrower to bring the loan current and stop foreclosure by paying all overdue amounts before the property is sold. After a foreclosure sale, John learns his state allows statutory redemption for a limited time. What can John do during this period? Is it A, negotiate a new loan with the lender, B, buy back the property by paying the foreclosure sale price and costs, C, force the new owner to vacate immediately without payment, or D, reduce the amount owed through a deficiency judgment? The correct answer is B, buy back the property by paying the foreclosure sale price and costs. Statutory redemption allows the former owner to reclaim the property by paying the foreclosure sale price plus any additional costs within a set period after the sale.
Thanks for watching. If you found this exam review helpful, be sure to subscribe for more real-world practice and topic-focused study videos. And visit birdsey.ai to start your free trial of Birdsey, your AI-powered study partner.